Thank you, Madam Speaker. Madam Speaker, I was hoping that this would not be long, but my contribution, but it may very well be long, a little while for me to expound upon my reasons for not supporting this bill. In order that no one gets the wrong impression. Madam Speaker, when I say I don't support the bill, which is the amendment to the Summary Jurisdiction Law 2006 revision to empower the Cabinet to make regulations providing for the training of justice of the peace and for incidental and connected purposes. I'm saying that because, Madam Speaker, I see this as the thin edge of the wedge. Meaning, primary legislation is enacted here in the legislature for the courts, such as the Grand Court law. And secondary legislation, if we can call it that, is promulgated by the Chief Justice on the operation of that law in the form of Grand Court rules. Madam Speaker, whilst I'm not any lawyer, I might be one of them family lawyers, I believe, and I still understand, the meaning of separation of powers. We as legislators, whilst there are some overlaps, such as the executive having to pay and approve the budget of the judiciary, my concern is that when we tinker with that, we may be creating the thin edge of the wedge. Thin edge of the wedge, Madam Speaker, because whilst I am firmly, or maybe, yes, firmly of the view or of the belief that men in this government or the government may not necessarily want to take this move any further. My concern is not this government. My concern is governments to come. Governments to come, because newsflash, this one won't stay here forever. Governments to come may very well view this as the opportunity to go and make further regulations to control the judiciary. Madam Speaker, that, as you well know, Madam Speaker, is a dangerous position for any country to be in. It scares me. I am concerned that this could be precedent setting and others capitalize on it. Yes, Madam Speaker, one may argue that I am paranoid. One may argue that I don't trust. No, I don't. I trust my shadow in the midday sun. Madam Speaker, the summary jurisdiction law. And I know, Madam Speaker, someone's going to get up here and say, oh, no, you're wrong. Governs appointment of magistrates, appointment of justice, removal of justice of the peace, composition of the court and exercise of jurisdiction, civil jurisdiction, criminal jurisdiction, places and times of sitting of court, all managed by the Chief Justice. Madam Speaker, I understand the government saying that this is only about training. And we're going to get to this thing called training. Because that is fish of another color, or a fowl. Madam Speaker, what is going to be next? Who is going to make further regulations to further operations, the further operations of this bill, of this law? Madam Speaker, now that I have laid out my fundamental reasons for not being able to support this bill to make regulations, I will go on to make some suggestions to this government and proposals on why, where, how we should be doing this. Madam Speaker, Justice of the Peace designation just happens to be for Caymanians. That is Caymanians' way of participating in the operation of this, the governance of this country, but more importantly, the justice system of this country. Contrary to belief, it is voluntary, because no one needs to accept a nomination for justice of the peace. As I recall, Madam Speaker, in yesteryear, we had quite a few justices of the peace. I can think back to people like Mr. Chaper, Mr. Warren Dade, Mr. Austin Nadis, and many others within the District of East End. Mr. Will, it is only given to Caymanians who we consider upstanding citizens of this country, who are worthy of participating in the administration of justice. In the days of Lincoln Barton from East End and the likes, I was not born when these people were doing it. I grew up seeing them do it. In the days when judges were visiting judges, and we had to put somebody in place here for the administration of justice, such as sitting in court, quote-unquote magistrates court, signing documents, attesting to the good character of people, or meting out justice within our communities. That's what it meant to us as a people. And we know the history of justice and the creation of the justice of the peace position, which is hundreds of years ago in England, when England did not see it necessary to fully complement our country with judges and the likes, because we were small in number, wasn't valued very much to them at the time, because we didn't have the plantation and arable lands and stuff. So we appointed our own people to administer the justice in the form of justices of the peace. Madam Speaker, we have grown since then. We have grown quite a bit. But we have remained stagnant in our movement of the administration of justice. So much so that in the minds of our people, minds of certain institutions, we still hold justices of the peace responsible for everything. Madam Speaker, I understand the need to train, because this jurisdiction has become so sophisticated in law. I think the Premier said has become extremely litigious over the last few years. And we got every lawyer coming in here, setting up firms, and they come not only for the financial industry, but also for the criminal industry, where they can make a name for themselves with their neon signs. They make a name for themselves on taking people to court. And the least little thing, the judges, one mistake by a lay justice of the peace causes this country to pay much. One mistake. And I am reminded that much can be said about a justice of the peace making mistakes. But even preachers are human beings too, because I see the lawyers just made one blunder out there the other day. And the judge. But we make a big deal about the justice making a mistake. Madam Speaker, it is an honorable thing to be appointed justice of the peace. I am. Madam Speaker, there is a need for training. I endorse that. I support the government in its effort to ensure justices of the peace do not make mistakes. However, Madam Speaker, there must be different categories of justice of the peace. For me, not being a lawyer, I don't know what constitutes prima facie evidence. I don't know what is probable cause, what constitutes probable cause. That's not my job to know that. That is the lawyer's job. to know that, and judges. So when we come to the training and the separation, I believe it is necessary that people like myself, lay justice of the peace, should be trained for specific jobs, such as the signing of papers for my people in East End, land transfer and affidavits and the likes and the witnessing of those and what have you. There are other areas that lay justices of the peace like myself can perform and stay connected to the administration of justice in this country, such as we have the courts imposing community service on when one is convicted of an offense, like the drug courts, which we now have established. I believe justice of the peace, such as myself, can ensure, can attest to signing off on those community services and the likes, such as in East End, if the judge sentenced someone to community service, I would know who they're working with, so I can go and confirm with those people who they are and sign it off. I can go and double check on them and the likes. Now, this action on the part of this government is a knee-jerk reaction to what transpired, and the Premier spoke of it. What transpired in two instances of recent history. One with the judge, Henderson, where the judge said that the JP was coerced into signing a warrant, a police warrant, and the other one where a lady said that the JP didn't read what he was signing and then signed an affidavit to that effect. No, you're talking about one in the same instance. I'm talking about the one where Mr. Carson Ebanks signed for the police go pick up Henderson, which cost us $1.2 million. No one wanted out, and they're getting it. Yeah, with Donna telling them to do so. That what the judge determined, adjudged. The other one was with Sandra Catron, which is a public document, saying that Doc Louis Ebanks, and didn't read it and didn't know what he was doing. And Madam Speaker, neither of those I believe. I want that made very straight. Should have investigated something. Madam Speaker, why? And I digress here a little bit. Madam Speaker, the morning that Mr. Carson signed that thing, I was in early. I'd missed Mr. Carson because he was usually in early. I asked about him. No one knew where he was. When he turned up to work, he came straight into my office and complained to me about the signing of a search warrant with him, with it saying that he was the officer of the court. And he said he doesn't know of him being an officer of the court. Of course, Madam, so I can say that he had concerns within minutes of coming back to the office. My response to him was, I'm sorry, but you're going to jail. Anyway, that was a joke that I passed with him. But I can't say he was concerned about it. I am further suspicious of the other case. For my own personal reasons, but so be it. Madam Speaker, this government is reacting to those two cases, and in particular, the latter one. Madam Speaker, I cannot, for the life of me, understand why. This is not the way to respond to those things. We are opening up a can of worms that we may never be able to close. We got bad enough. We got it bad enough trying to establish the autonomy of this parliament, of this legislature. It'll be worse when we step over that proverbial line that is drawn in the stand with the judiciary. That needs to be steered clear of. Madam Speaker, the Chief Justice. The Premier said that the Chief Justice was consulted. Now, and I say I'm disbelieving the Premier, he was reading what someone else had written. Madam Speaker, I didn't say I disbelieve the Premier. Obviously, from what because he wasn't supposed to be bringing this, so I suspect that he was coached, he was briefed, so to speak, on what the status was. I ain't calling nobody a liar. No, Madam Speaker, I would never disrespect anybody in here like that.
Once you're not inferring that the person who read it currently sits in a chamber, then you're not in breach. If that's your intent, then please deviate from that intent.
Madam Speaker, I never said that. God forbid, I would never say any such thing. Madam Speaker, that the Chief Justice had been consulted. I don't know what part the Chief Justice has played in this. I believe, and like I said, I don't trust anyone, Madam Speaker. I would like to see to do Reagan thing. Trust but verify. But well, you don't go ask him, bring it back. Madam Speaker, I believe what needs, you can get back up anytime you want. Get up now on a point of order, I'll sit. You can say anything you want. I say, well, you know. Or it don't make sense to you. You're the smartest person in this world, in this chamber. Got two more brains cells than me, and they're not no good to you.
Order, members. Member from Easton, please continue your debate.
Madam Speaker, the Premier better don't challenge me on it, you know. Okay? You better be careful. Madam Speaker, you know, sometimes maybe I shouldn't try to save anyone. Madam Speaker, I too have consulted on this bill. I too have consulted on this bill, and quite widely. And I can assure this honorable House and the smartest premier we have ever seen that I was advised that no consultation was done. Okay? Madam Speaker, the responsibility, I believe, of you're the smartest lawyer now too, huh? No, I want to know where he getting his information from over there. Obviously, it's not reaching you right. Pray somebody help him with them Q-tips over there. Madam Speaker, it is my view that the summary jurisdiction law should be managed by the Chief Justice and him alone. Madam Speaker, this government, or any government, and in particular this government now, needs to provide the necessary resources, financial resources, for the Chief Justice to get done what he needs to get done with justices of the peace. Cabinet has no place to make regulations on training. If there is a need for training of the justices of the peace in this country, Cabinet need only request that the Chief Justice do it and utilize his justices of the peace in the proper manner. Madam Speaker, I can show you what the administrative arm of this government did recently. It's an affront. What they did was an affront to some of the justices of the peace. When they sent out a letter saying that you had to be trained, you had to participate in the training, or they were going to rescind your designation as a justice of the peace. Madam Speaker, the emphasis of that training, see the Attorney General with quizzical eyes. The emphasis of that training was the case with Sandra Catron and Mr. Louis E. Banks. Which I understood and I appreciated because it enlightened me. Madam Speaker, what was an affront to the justices of the peace was that in 2013, this Attorney General came here and appealed the notary's bill, notary's law, and then amended the law to say that accountants and lawyers were exempt from training to be a notary public. Now, let's get back to the front so we can compare it with what I just said. Madam Speaker, the only person's justice of the peace designation is bestowed upon are Caymanians. Let's name some names. Your good self, the Premier, the Minister for Financial Services, the Minister for Finance, Minister of Education, David Rich, 40 years of practice as a lawyer. First as a prosecutor, then as a magistrate, then as acting attorney general, then as defense lawyer, 40 years, 1976. Okay? 40 years of practice. And he had to go to training because one JP had signed, ostensibly signed, his police search warrant incorrectly. Adriana Webb, 40 years of practice, had to go. Charles Clifford, police officer, chief officer, politician, lawyer, prosecutor. You think that's not an affront? To go to be trained as a justice of the peace on how they should sign a police search warrant, what they must look for, the questions they must ask by a civil servant. And no disrespect to the lawyer that conducted it, a lawyer of recent qualification, maybe 10 years, I don't know, 5, 10 years. Madam Speaker, I understand the leader of the opposition, I understand myself, I understand the member from North Side, I understand the other member from West Bay. Madam Speaker, we don't know anything about that. But we can do other little things. Every lawyer that has been given that had to go, that the justice of the peace designation has been honored to hold that designation of justice of the peace, had to go to training by a civil servant. That is what this has caused by the administrative arm of government dabbling in it. It needs to stay with the Chief Justice. Let him decide how he uses his justices of the peace. Who appoint them? The governor appoint under who? where they use, not under the summary jurisdiction law. Madam Speaker, the Premier read off about what the regulations are going to stay. I got them too.
You got a regulation that they already appropriated, treat people on, that don't exist. And when you ask them about it, oh, we didn't know it needed to be passed by the but we couldn't do it, we did it.
Madam Speaker, I went to the training in April or May, I believe.
You got a copy of the regulation? 1013.
And the regulations had already been written. And I asked them, under which authority? Because the summary jurisdiction law does not make provision for it. We are doing it now. Madam Speaker, you want a copy? Good. Taj, come. Justice of the Peace Regulations, 2013, Arrangement of Regulations.
So order.
You see, Madam Speaker, the problem here is that appears like the executive thinks they must do everything. No one else is good enough to do anything. Newsflash, you're not in charge. Got it? You are enabled by this legislature. And I hope somebody carries that message to the Deputy Governor too. Madam Speaker, I didn't get up here with any intent of opposing the intent of the government to ensure training is done. It's just that this is not the place to do it. And cabinet is not the place to do it by virtue of secondary legislation. We are going to cause a problem. But of course, you know what? People would have me sit here, not open my mouth, and allow them to do as they please. Another news flash. That is not going to happen. Madam Speaker, in my research, there are many places, not only in the Commonwealth, but throughout the world, where search warrants are required to be signed by magistrates or judges. Madam Speaker, you understand now? Let me get the police law, because I've been at this now ever since they sent it out. Thank you, sir. I believe 44. Section 44, Madam Speaker, of the police law. He who got Bible, follow me. I'm preaching today. You bring your Bible, follow. Notwithstanding Section 26 of the Criminal Procedure Code 2006 revision, or any amending or superseding version, this section has effect in relation to the issue to police officers under the law of warrants to enter and search premises, and an entry on or search of premises under a warrant is unlawful unless it complies with this section. 2, where a police officer applies for any such warrant, it shall be his duty, A, to state, 1, the ground on which he makes the application, and 2, the law under which the warrant would be issued, B, to specify the premises which it is desired to enter and search, and C, to identify so far as practicable the articles or persons to be sought. 3, an application for such a warrant shall be made ex parte and supported by an information in writing. Subsection 4, the police officer shall answer on oath any questions that the justice of the peace, magistrate, or judge hearing the application ask him. And then it goes on to say that the warrant is for one occasion only, and what needs to be listed on it and stuff. Now, Madam Speaker, they waking me up 3 o'clock in the morning. Why they can't wake up judges? Madam Speaker, there is no need for us to react the way we have reacted to this thing. None. The provisions are there. Magistrates can do it. Now, Madam Speaker, I spoke earlier when I started about how we have come of age and the purpose of the magistrates when they were first introduced in this country, because we only had visiting judges. Remember I said that? And they will come once a 6 months, once a year, if we were lucky. Now, Madam Speaker, I also said that this country has become extremely sophisticated. So much so that we now have a judicial commission who appoints judges and the likes, and magistrates. Madam Speaker, nobody must tell me that magistrates can't do it. Madam Speaker, 3-4 months ago. The newspaper were big with us appointing 4 new part-time magistrates. And how many we had in court permanent before that? 4 too. So, Madam Speaker, we have at least 8 magistrates somewhere throughout this country. Don't worry. There's one living fence with me right behind me. So when a policeman come to me, I'll send them my backyard. Now, Madam Speaker, the magistrates can be called upon to sign police warrants. They are the most suited to do that. And then, when the Chief Justice feels overwhelmed and his court is overwhelmed with the work, he must call upon the David Rich, the Adriana, the Charles Clifford, the this one, that one, to sit in juvenile court for him. There is very little need for laymen to sit any longer. But we need to train all our long practicing lawyers on how to sign a search warrant and what to look for. That's what we do. Why is that? Let me proffer an opinion. You know what it is? In my view, Madam Speaker, remember I said my opinion now. Because Caymanian. That's why we are not valued enough to not go through that training. But all those who come here don't need to be trained to be in North Republic. They know it all. But our lawyers that we have groomed, we have reared, who have become successful, well, you know, we don't trust you. We need someone who's not a lawyer to show you how to do this. That's what we got to do. And we want you to keep records of every document you sign. Just in case something happens, we want to come back and see what you did. Even that, I'll concede. But why do we need to train our lawyers? And the lawyers who are North Republic are exempt. And accountants from training to be a North Republic. Madam Speaker, I understand. And I know the argument is going to be, oh, well, the North Republic doesn't have the jurisdiction that the justice of the peace have within our justice system. I understand all that, Madam Speaker. So when they come, they gotta come with them bazookas. I don't know what you're talking about and all that. I understand that, Madam Speaker. That justice of the peace has more authority within the justice system and needs to be trained. So tell me, why then Are there the notary publics trained? There are the notary publics that need to be trained. But we can exempt the lawyers. I don't see no. Madam Speaker, I gave you a copy of these proposed regulations, arrangement of regulations, by and large, what it will say, I guess. I don't see nothing about Caymanians, lawyers not being trained.
The regulations, and this is what they were trained us on now. That's what the man told me. I was there, arguing.
Yeah.
These are the regulations. He told me they were already made.
I trust that the government is going to exempt our good lawyers from this. Madam Speaker, they are the ones who understand, what do you call it? Prima facie evidence. Probable cause. That's the kind of stuff they're asking me to look for when I am to sign a warrant and to ask questions. And I understand that, Madam Speaker, because I was never trained in it. But you're not going to train the lawyers to tell them that's what I look for. You're not going to train the judges, the magistrates, to tell them that's what they got to look for. Let's take it there. Even in England, magistrates are required to sign police warrants. Many other places in the Commonwealth, Australia. In America, it's circuit judges, so I suspect they are on par with our magistrates. But we are using this opportunity to demoralize, maybe is the word, embarrass. And I know the Premier is going to get up political and attack my position. That's fine. But at the same time, the political directorate has no jurisdiction over it. But they send him out the front, they get at me, you see. Say it now, so? You know, tune it, so. Madam Speaker, for what do we try to participate in our country's governance? For what? We got people like Mr. Bernard Watler, the older ones. Name some of them for me. Richard Arch, all these people who this was bestowed upon. Olive Miller. East End, we got preachers, we got Northside College, Conley, name it. Is it because they're Caymanians that we have to impose this because we don't trust them? What is it? Madam Speaker, every time we try to float the boat, somebody puncture a hole in a van. And they rejoice. News flash again. You better don't, because you're in the same boat. And she's going to sink. And you're going to get wet too. Unless you start bailing. Madam Speaker, I support the government in its approach approach to this to ensure that there is continuous training, like the Premier say, in other jurisdictions, it is so. Because this is a respected position, we need to ensure that the public has confidence in the justice of the peace and what they're doing. I agree with the Premier, but let's not do it this way. If we have consulted with the Chief Justice, can we not say to him, please, since they are officers of the court, let us know what it takes for you to conduct training on a regular basis and allow the courts to do it? Isn't that how it's supposed to be done? Who's going to do this? Madam Speaker, by no stretch of the imagination can I see this not being an embarrassment, at the very least to some of our JPs. Every 6 months, people like David Rich and Adriana Webb are going to have to get updated in training, or once a year, once every 2 years, I don't know. It cannot be fair to the very people who upholds, who morally, ethically are required to uphold the tenets of justice in this country, and we have to train them to be a JP. What are we bringing out so new, so often, that we need to train these lawyers? I don't even know if lawyers go on continuing education. Somebody tell me now. But because you're a justice of the peace, you need continuing education and training. I don't know. I mean, Miss Adriana Webb, what's she was? Commissioner twice now. Boundary commissioner. All the appeals, appeals boards, tribunals she's been on. Spend all her life in practice, but she do more conveyancing and that kind of stuff, but still in criminal law. It just bothers me, Madam Speaker, to see us what we do to our people. We tell our people, for you to achieve your dreams, your hopes, your goals, your aspirations, you need to be trained. You need to get an education. Then somebody pull the rug from under us again. Tony, that's what's happening. Why are we doing this? But then here, someone comes here with the same qualifications, and they don't need the training because they got experience. And David Rich and Adriana got 40-odd years of practice. Still not enough for us. Who is directing this? Then we bring lawyers into our country. All it requires 5 years of PSD, it is? 3 years. PQE, post-qualification train experience, PQE. Within a year, 2, they become North Republic. And they don't need training. Adriana, 40 years. David Rich, 40 years. Train them. They don't know what they're doing. You think it's fair? You think that doesn't bother me? Yeah, for me, I need it. I need it. Also, you need too. Minister of Health, you need it too. All of us. Because there are many documents I don't understand, and you know, I need the training. I welcome it. David Rich here, it might be here, they sign them same documents out there about land transfer and all that, and Adriana and all that. You got to train them, show them how to do it. New way of doing it. Put your signature on this line as opposed to that line, and stop it. You can't make your signature come over the line. It must be that. Because it's not changed. Tell me. Madam Speaker, I don't know what more to say. I know I'm not supporting it. I will not support this affront to some of our people. I will not support this teenage of the wedge between this legislature, cabinet, and the judiciary. I'm not going to do that. Leave this up to the Chief Justice, sends their officers of the court. Don't we go over there and tell him how to train the clerk of courts and the attendant staff there and the, what do they call the ones with the marshals? We don't. Leave it up to him. Provide the resources for him to do it. Why are we getting the deputy governor office and things that don't concern him? Not because he's a lawyer, no, that he thinks that he can take over the judiciary. I have said before, when we start second-guessing the judicial system in our country, we have a banana republic. Is that the direction we want to go? Where the political directorate can dictate to the judiciary? God forbid that ever happens in this country. Stay as far away from them as possible. They have no control over us here. All they can do is say that the laws we make are not compliant with human rights. That's the extent of their involvement here. They have no business to send back anything here. We have no business to go at them. Let this not be the beginning of it. Let this government not be the start of something that we cannot stop, and it destroys the very foundation of the justice system in this country. I don't know what more to say. I guess I must be fooled. I know I will be made out to be a fool. But Madam Speaker, it's my position. And all I'm doing is asking the government to stop this. There are different ways of getting it done. We have the jurisdiction over primary legislation after consultation with the Chief Justice. Why are we getting into secondary legislation to manage that primary legislation? It's wrong. It's on need. There's no need for it. It's uncalled for. I don't don't know what is going on between the executive arm and the Chief Justice and the justice system. I don't know. I don't need to know. But I trust the administrative arm. I trust this is not a response or a reaction to something that is personal or anything of that nature. Because I'm not going to be a part of it. I refuse to be a part of that. Whether it's that or something else. I want to stay away from that as far as east is from the west. I will not be held responsible in years to come when they say, well, you started it. Not me. I'm going to record my objection to it. Madam Speaker, I don't know, maybe, and I stand to be corrected, but the government hasn't said anything yet that I can find, then I can hang my hat on to justify this. Again, if we are concerned about the conduct of the justices of the peace, get the Chief Justice to do what he has done with the rules of the Grand Court. I know the legal practitioners bill. We're not getting no code of conduct in that. That's another one coming soon, I hear. Yeah, you know. Waiting for you with that one, too. No, Madam Speaker, I believe there has to be a different way to do this. The court has always been the ones who conduct the training. The magistrates, the woman there, Donaldson, no? As magistrate used to do the training. Why is it no? They're not good enough. Why is it they just appoint Hernandez? Who else? Hernandez, some Wallace or something, and some other man, and Adam Roberts. I don't want to live back to me, so when I come, that way I'm going. And one other one. And then you had Donalds and the must be 3 or 4 out there as well. Madam Speaker, they can do the training. They can, if they got hire people from on the outside, and engage people from on the outside, then fine. But training must be under the auspices of the court. When it's convenient, we say that the justice of the peace now have a responsibility because they're officers of the court. But when we want to train them, they say, oh, it falls under the deputy governor. And we have to see to it that they are trained. What are we doing? We want to flex our muscles or what? Madam Speaker, I shall respectfully take my seat and, should I say, prepare for the onslaught? That which I have always had to endure, but so what? The government needs to convince me that this is the right way to go about this. I am not convinced, and until I hear from the Chief Justice that this is the way it should go, and I will not support this being done. Yes, Madam Speaker, I am afraid. I am concerned. I am very, very afraid to be a part of a precedent that potentially could be damaging, could have more consequences than the intent. I am concerned. I'm afraid of it. And I'm not going to take part in it, Madam Speaker. Thank you.
Does any other member wish to speak? I recognize the honorable member from the District of Northside.
Thank you, Madam Speaker. Madam Speaker, I endorse what the member for East End said. And since this whole thing is being done because JPs need training, I want to talk a little more about the actual training that we were subjected to as a JP. Because, Madam Speaker, training for JP is not new. This is not the first time it has ever happened. This is not the first time it has ever been thought about in the Cayman Islands. I was appointed as Justice of the Peace in 2004. And, Madam Speaker, I went to training sponsored by the Justice of the Peace Association and done by a magistrate from the courts. And we received, in my view, Madam Speaker, very good training. Now, Madam Speaker, when I got the letter from the Deputy Governor that I must attend this training or they were going to disappoint me, I asked him how he was going to disappoint me. Because most of the JPs in Cayman up to that point, it was considered a lifetime appointment. He said, well, we can change the law so we can do it. I said, okay. I said, well, what about the Justice of the Peace that already received from training by the magistrates? Do we still have to come too? Oh yes, you all have to come. So I got this email by one of the officers of the, I believe is now in the Deputy Governor's office, but been around here so long and been in so many offices that it's hard to follow him. I don't have a GPS tracker on him. And I told him, if the training was going to be done by Peter Goff, they could take my appointment that day. Because in my view, there was nothing he could teach me about being a Justice of the Peace in Cayman. So I got a letter back and said it was being done by an attorney who I have respect for. And I have basically decided from then that I was going to resign as a Justice of the Peace. Because what we are molding and morphing a Justice of the Peace into today is not what Ezra signed up to be. Justice of the Peace that I signed up to be was a person who has a certain standing in the community, who had earned a certain reputation of honesty, integrity, law-abiding within the community. And you were basically appointed as a Justice of the Peace to perform certain functions in the community for free to the community. And normally, certainly me, I didn't expect anybody under 45 to ever be appointed Justice of the Peace. In fact, Madam Speaker, I was offered by Governor Scott when I was a member of Cabinet to be appointed Justice of the Peace, and I refused it because I didn't think I'd earned it at 36 years old. Because the kind of people who were Justices of the Peace in my community up to that point were the elderly stalwarts of the community. Mr. Snedden McCoy, Mr. Crelocky Banks, before them people like Mr. Tideman, people that everybody in the community respected. And I was too young a Turk at 36 to believe that I had earned that kind of respect in my community already, although they had trusted to elect me as their representative, and my peers had trusted to elect me to Cabinet, that time called EXCO. I don't think that I yet met the qualification to be a Justice of the Peace. So I refused it at that time. Now, Madam Speaker, I went to this training. I was handed a book, a manual, and they distributed these regulations that the member for East End table. Asked, well, when were these regulations made? He wasn't sure. I asked, does the regulations, are they going to be subject to an affirmative motion or subject to negative resolution, or they're not coming to Parliament at all? He didn't know. He didn't know what it, he didn't know that made any difference. And Madam Speaker, now you know, he is the one instructing the attorney to train us now, you know. So I pointed out, as did some other respected attorneys in the group that I was in, because we did different groups, that, you know, the law at that time did not allow the Cabinet to do this. So we kind of passed over that. Then, Madam Speaker, he started to distribute stamps. Big old, bulky, ugly looking something. But one of the stamps was said on it, I hereby certify that this is a copy of the original. I asked the question because when I was trained by the magistrate, I was told I could not write that on a document. And at that time, I asked the magistrate the same thing. Why? The magistrate told me that the only person who can certify that something is a copy of the original is the person who made the original. So we were instructed in the group that I was trained as a JP to write, I certify this is a true copy, but not of the original. And I told him that I believe that that stamp was going to get people in trouble. The solution to that was he gave everybody else in the room one of those stamps except me. Now, Madam Speaker, like the member for East End, I believe in training. I endorse that training should be done. But it must be proper training. It must be done by people who can teach us something. One of the experienced attorneys asked the question, now that the JP stamp is going to carry a number which identifies that person as that JP. What protection was the regulations of the law going to provide for somebody who used that number and it wasn't him? Because he said that this identifies me now. I had no clue. Again, just passed over. So, Madam Speaker, while I always believe in training, my grandmother used to tell me, never go to sleep at night unless you learn something new that day. And I have lived by that. And if it's nothing else, I go on the internet before I go to sleep and find out the price of something, because that's something new, right? But, Madam Speaker, when we start, as the member for Eastern say, taking these things away from the people that we know are equipped and trained for this stuff and giving it to administrative officers to do, we have to be concerned. And, Madam Speaker, Madam Speaker, it is, I'll give you an example of how, I don't want to say insulting, maybe demeaning is a better word, but a very good friend of mine who is not a CPA but has a master of accounting, holds a chief executive job in a very respected international company, sits on the board of our utility company here, came all the way from overseas to do the training, but got held up in a meeting so he couldn't attend the full second session. And this administrative officer look at him and tell him, I'm not giving you the stuff because you haven't completed the training. No, I went on so bad that he gave him everything. But that's the kind of disrespect that these people feel at liberty to perpetrate on our people. And the elected arm don't have nothing to do with this. They bring the law, and I believe them for that, and I'm voting against it. Because I believe from Memphis East End, they should take this back up there and tell them civil servants, we handing this over to the Chief Justice and we can leave it there. That's where it has always been, and we can leave it there. We are not allowing you to conswabble us into doing the wrong thing. Because I know they have good argument. They gave the arguments all within the chambers around here to me why it was necessary to tamper with this legislation. And Madam Speaker, the next thing that I expect to see about this legislation is the expansion of appointment of virtue official justice of the peace. Beyond this, because I believe that quite a number of civil servants have been appointed as justice of the peace recently, mainly because of the administrative position that they hold. And Madam Speaker, those kind of people should be appointed notary public. If they don't have the exception, the government should pay for the training, and if they want to remain notary publics after they mid office, they pay for it. Because some of those that I hear have been given JP status, I believe fall in the category I was in when I was a member of EXCO in the late 80s and early 90s. And, Madam Speaker, again, I'm not trying to be disrespectful to any of those civil servants who have been appointed, but this is my concern about justices of the peace and what it is being morphed into, as opposed to what I grew up under the tradition of justice of the peace. And Madam Speaker, I will support an amendment to the police law right now to remove from the police law the ability of justices of the peace to sign warrants, because I understand the difficulties that might exist in some JPs making an error, and the police officer tricking them to get a warrant. And I believe that this day and age, I don't think justice of the peace should be signing search warrants and such. Leave that to the magistrates and judges at the court. As the member for East End say, we got enough for them now. They can take turns if they don't want to all be waking up at the same time. And Madam Speaker, again, I don't understand why we are introducing all this stuff about people haven't been able to carry the title honorary and all that sorts of stuff. Because most of the JPs that I know who've reached a point in life where they don't believe they're capable of signing these documents simply don't do it anymore. But we still leave them with the title. We don't take the title away and replace it with honorary. So, Madam Speaker, I think this bill is unnecessary. I think it goes too far. And most importantly, Madam Speaker, I believe the training should return to the courts, and the training should be done under the auspices of the Chief Justice. Whether he delegates it to the magistrates or other judges, that's fine with me. If he's the Chief Justice of the country, he can be relied upon to make that decision. I think when we have administrative officers in the government doing this training, we're trading on some dangerous ground. So, Madam Speaker, I am not going to support the bill in its present form. And, Madam Speaker, you know, some of the attorneys that Mr. McLean mentioned, instead of dragging them in to a session with people like me to be trained as JPs, we should be honoring them, holding them up and giving them silk. But even that, we give to others other than Caymanians. Because, in my view, some of them have certainly earned it. But again, we always seem to find reasons not to give it to our own people. So, Madam Speaker, in the present form, I will be voting against the bill.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call on mover if he wishes to exercise the right of reply.
Thank you, Madam Speaker. Madam Speaker, I could not begin to imagine that this bill would have drawn such venom from my friends across the way. And I have sat here a bit bemused, but I've gone through the draft regulations which were referred to, particularly by the member from East End, and search them as I might. I see no reference to training being conducted by any specific group of people or entity or under the jurisdiction of any particular office. So, Madam Speaker, I really don't understand where all of this talk about separation of powers and somehow this legislature and the cabinet, by virtue of its ability to make regulations, interfering with the separation of powers and going down dangerous paths and all of that really, really sensational and scary stuff. But, Madam Speaker, trying to sort through the rhetoric of the rambling speech made by the member from East End, I think I've been able to distill two objections on his part to what is being proposed. The first is that training should not be required for persons who have the necessary experience and education and training. He listed some, I think most of those were lawyers. And the second was his concern about the embarrassment to justices of the peace, current justices of the peace who were written to and asked to participate in the training exercise, or else they ran the risk that their appointments as justices of the peace would be revoked. I think that's the basis for the objection, as best as I've been able to distill it. And as an extension of that, that the regulations ought not to be made by the cabinet, but to be made by the Chief Justice. The cabinet should not have the power to make the regulations. Well, Madam Speaker, if that were the case, this would be the only piece of legislation that I am aware of in the Cayman Islands that the cabinet doesn't have the ability to make regulations for, by one means or another. And I don't, Madam Speaker, quite understand why that would be the case. Madam Speaker, the establishment of justices of the peace is an ancient thing coming down to us from Britain. And I say Britain and not the United Kingdom because it goes way back to the 1300s. From then, they were justices of the peace. And they've had many, many responsibilities, some very, very significant. They are able to sit, and this is still the case, they're able to sit as lay justices in summary court. They're able to issue warrants, search warrants, and others. They're able to sign charges. They're able to witness signatures with respect to legal documents. A whole range of functions and quite distinct authority. Madam Speaker, why anyone would take it as an affront to be asked to participate in training is beyond me. I don't believe, Madam Speaker, that one should allow arrogance to prevent you from being properly educated and trained in whatever area you're supposed to work.
Madam Speaker, on a point of order. Madam Speaker, the Premier, I don't know if he understood what I said. I said it was an affront to all those experienced lawyers who have been trained in law to be able to be required to go after 40-odd years, and I call his name as well, 30-odd years of criminal law. It's an affront to them for and the administration to tell them that they got to take away their designation if they don't get trained in the issuance of police records, because that was what it was called for. I welcome the training for all lay JPs, so he needs to clarify that for me, please.
Honorable Premier, that was more of a elucidation.
That's fine, Madam Speaker. It helps. But it does nothing at all to the point I'm seeking to make. It does not matter that you're a trained lawyer. This month, I complete 26 years of call to the bar. The Attorney General has done more than that. All of us have gone through the training program. If the member or anyone else doubts me, I'm happy to lay it on the table of the House. Because, Madam Speaker, and I'm going to come to that, it is important that all of us recognize that we don't know, because we've gone to school 25 years ago, that that does not necessarily mean that we understand what the current law is with respect to a range of things. And I, for myself, Madam Speaker, would never take it as an affront to be asked, as I was asked, to participate in a training program to help me understand better what is necessary to function as a justice of the peace. Madam Speaker, this has come about, and the member from East End knows well because he spoke about it, because of recent instances here. In the case of Operation Tempura, the execution of a warrant, not the execution, the signature, the issuance of a warrant by a permanent secretary in the government to allow the police to go and search and ultimately arrest a sitting judge of the Grand Court cost this country $1.275 million. We've had the more recent case by Ms. Sandra Catron. I don't know if that has or if it will wind up costing the government any cash in terms of compensation. But it has certainly caused major embarrassment and certainly caused the dismissal of the case in question. Now, Madam Speaker, just in case the member from East End thinks that that is be all and end all of it, I recall very well the case of Ray and Gibbs against the Commissioner, of Ray against Gibbs, the Commissioner of Police and the Attorney General in 1995, in which a sitting judge of the Grand Court, Mr. Justice Schofield, issued a search warrant on behalf of the police against one John Ray. You know what happened? The Court of Appeal found that the issuance of the warrant was unlawful and ineffective, and it had seriously damaged the reputation of Mr. Ray, and the Cayman Islands government was required to pay $566,281 as special damages and $50,000 as general damages to Mr. John Ray. This is 1995 money we're talking about. So that's probably the best part of $1 million now. If a sitting judge of the Grand Court can get it wrong, who am I as a lawyer who has not been in active practice for the best part of 14 years to believe and to be so arrogant as to say, I don't need the training? We should welcome this training. The members from East End and Northside should be lobbying to ensure that those who have the responsibility, the authority, and the status of justices of the peace have the requisite training and ability to carry out the function. For I know, Madam Speaker, that no one in this House, more than those two, would jump on any opportunity to cut off somebody's head because they made a mistake and it costs the government money. That is their specialty. But, Madam Speaker, what they are seeking to do today is to try to build something from nothing, to try to make some kind of platform to climb up on and talk about how the government is insulting Caymanians, and the government is party to this, and the government is party to that, and to throw derision at the Deputy Governor and his office, and to say that this cabinet doesn't know what it is doing, and to suggest, as the member from East End did, that somehow I was given something to read by someone and I don't understand what I'm reading. Madam Speaker, the 2009 Constitution, Section 44, subsection 3, vests in Cabinet, not the Governor and Cabinet, vests in Cabinet the responsibility for the formulation of policy with respect to all aspects of the government of the Cayman Islands, save the special responsibilities of the Governor, which are the public service and national security and external affairs, to the extent that those have not been delegated to ministers. And also vest in Cabinet responsibility for the implementation of those policies. Any matter, just for the avoidance of doubt, particularly on the part of that member from East End, any matter that is brought down here, my caucus and my cabinet have agreed to it. We don't function any other way. The Deputy Governor doesn't tell us what to do. The Attorney General does not tell us what to do. They advise, they suggest, they propose, but they have no vote in cabinet. So we take responsibility for what is brought here, and I as Premier take principal responsibility. If the Deputy Governor had been here, I would have let him bring this bill on behalf of the government, because he is the one who has done the work with respect to it. But he is not here. And as Premier, it is my responsibility to make sure the business of the government goes forward. And I will never shy away from that responsibility. So the member from East End can cast as many aspersions and slurs and whatever he wishes to do. But he knows me well. And one thing I don't do is duck responsibility. Madam Speaker, what really is the objection to what is being proposed? Who does the training, it seems to be? That, Madam Speaker, is a matter for those who are in charge of this process. In the past, a range of people have been used to help with the edification process. This is not enshrined in the law. It's not enshrined or not proposed to be enshrined in the regulations. Who actually carries out the training? All that the regulations say with respect to it, and I alluded to this when I was presenting the bill, is it sets out a process. And for the benefit, particularly of the member from East End, I will refer to the draft regulations again, and the draft regulation 3 called the nomination process. Nominations for persons to be appointed as justices of the peace will only be accepted from registered voters. Nominations will only be accepted when made on the prescribed form as attached in Schedule 1 to these regulations. The nomination form should be accompanied by 1, a reference letter from 2 referees who must be registered voters or have been resident on the islands for 10 years. 2, a curriculum vitae. The nomination form and attachments must be submitted to the clerk of court, who will acknowledge receipt. The clerk of the court will forward copies of the nomination form and the attachments to the Chief Justice and the President of the Justice of Peace Association and the Attorney General for comments. The clerk of the court will carry out a due diligence exercise and background check on the nominee, including a police report. Once consultation responses are received and the background check acquired, the clerk of court will interview the nominee, explaining the duties and responsibilities of the role of justice of the peace. If the reports and the result of the interview indicate that the nominee is suitable, the Chief Justice shall approve the nominee to participate in training. Following the nominee's completion of the training and after further consultation, the Chief Justice will send all documentation to the Governor with a recommendation. Now, Madam Speaker, for the life of me, I cannot see how somehow what is being proposed is sidelining the Attorney General, sidelining the judiciary from involvement in this process. It doesn't even go to the Governor unless the Chief Justice sends the recommendation. Following the nominee's completion of the training and after further consultation, the Chief Justice will send all documentation to the Governor with a recommendation. I'm trying to help the member from East End who doesn't seem to understand. Madam Speaker. You want me to help you a little bit about the Chief Justice? Madam Speaker, the appointment of Justices of the Peace is not a matter for the Chief Justice. It is a matter for the Governor. Neither the Chief Justice nor the Judicial and Legal Services Commission have authority under the Constitution or anywhere else for the appointment of Justices of the Peace. The Constitution deals at length with how judges are appointed, the establishment of the courts, of the Grand Court, and of the Court of Appeal, and it says that where a summary court or summary courts are established, the summary courts shall be under the jurisdiction of the Grand Court. And so the Chief Justice and the Rules Committee can make rules with respect to the operation of the summary courts. Justices of the peace, as I indicated at the start, have a range of responsibilities, not all of which, in fact, most of which are not judicial in nature. But they do, from time to time, function as lay justices, and they are entitled and authorized to issue warrants. So there is involvement in the judicial system. But they are firmly under the purview, remit, and authority of the Governor, not the Cabinet, not the Chief Justice, but the Governor. And that is the distinction which the member from East End does not quite seem to grasp. Nothing that is being done here is in any way overstepping what the executive or the legislature should do or can do or is authorized to do. We are simply...
Madam Speaker, I wonder if the Premier would give way for elucidation.
Honorable Premier.
Of course, Madam Speaker.
Please continue, member from Easton.
Thank you, Madam Speaker. Madam Speaker, I wonder if the Premier, in his winding up, could tell us, take a look at the composition of the Grand Court, 9 to 5. 7, the Chief Justice shall have responsibility for and management of all matters arising in judicature, including responsibility A, for representing the views of the judiciary to the government and the legislative assembly, including where appropriate through the Attorney General. B, for the maintenance of appropriate arrangements for the welfare, training, and guidance of the judiciary within the available resources. C, subject to paragraph D, for the maintenance of appropriate arrangements for the deployment of the judiciary and the allocation of works within courts. D, after consultation with the President of the Court of Appeal, who shall be responsible for the allocation of work within the Court of Appeal for the maintenance of appropriate arrangements for the work of that court.
Honorable Premier.
Thank you, Madam Speaker. The member from East End reads well. But I don't know, I don't know how any of that changes anything that I've said. I've just been at pains to explain that that justice of the peace have functions that are outside the judicial process. The reason why, and that is recognized in the proposed amendments and in the proposed regulations, which is why there is clear involvement contemplated of the Chief Justice, the Clerk of the Court, the President of the Justice of Peace, and the Attorney General with respect to these matters. As I said, Madam Speaker, I just don't quite understand the very, very serious objection, fundamental objection, which the member from East End and the member from Northside to a lesser extent seem to have with the amendments and indeed with the proposed regulations, which are not really even properly before this House. And so, Madam Speaker, I can only put that down to they're the opposition and they wish to oppose. They have really, I think, not even made a mountain out of a molehill, because we didn't have a molehill to start with. There is absolutely no basis, Madam Speaker, in fact or in law, or even in their speculation, for them opposing the amendments to this summary jurisdiction law. The government would be beyond irresponsible if, having seen what has transpired in recent times, we did not take steps to ensure that those who execute the important function of justice of the peace were properly trained. And members, Madam Speaker, really have to get beyond the point where they take affront when they are asked to participate in training programs which will enhance their ability to properly serve the people that they were elected to represent. Madam Speaker, the government, at some expense, has gone to the trouble to organize, through the Deputy Governor's Office, proper training exercises to ensure that all who wish to remain as justice of the peace have had the opportunity to ask questions of those who know and to learn the proper execution of their duties. None of us should believe that we are so big, so bright, so experienced, so old, that we cannot benefit from guidance from those who know better. Every single member of this, minister of this government who's a justice of the peace has gone through the training program. The Attorney General of these islands has gone through the training program. The Deputy Governor has gone through the training program. Madam Speaker, why would it be that the two members from East End and Northside think that they should be exempted from this process? And so, Madam Speaker, I regret that on this occasion...
Madam Speaker, on a point of order, the Premier is misleading this House.
Member,
he knows I did not say that.
I can only have one member standing at the same time. Please state your point of order.
Madam Speaker, he's saying that the member from Northside and myself does not want to go through the training. I never said any such thing. I welcome the training, and he needs to withdraw it.
We got our certificates.
Honorable Premier, I think all along he's maintained the position that they did attend to the training and asked questions, so one can reasonably assume that they attended the training.
Well, Madam Speaker, I'm sorry. In all of the objections, I missed that, but I'm happy to learn that
because you wasn't in there,
that they did go through the training program, and I hope, Madam Speaker, that like the rest of us, they will find that it helps them in carrying out their duties, not just as justice of the peace, but as proper representatives of the people we were elected to represent. And so, Madam Speaker, Madam Speaker, without more, I will encourage all members of the House, even the two objectors, to give this bill their full support. Thank you, Madam Speaker.
The question is that a bill shortly entitled the Summary Jurisdiction Amendment Bill 2004 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no.
No.
Madam Speaker, may we have a division, please?
Honorable Premier has asked for division. Madam Clerk, please call the division.
Honorable Alden McLaughlin.
Aye.
Honorable Moses Kirkconnell.
Aye.
Honorable Kurt Tibbetts.
Aye.
Honorable Osborne Bodden.
Aye.
Honorable Wayne Panton.
Aye.
Honorable Marco Archer.
Aye.
Honorable Tara Rivers.
Aye.
Honorable Anthony Eden. Mr. Winston Connolly. Mr. Roy McTaggart.
Aye.
Mr. Joseph Hugh.
Aye.
Mr. Alvis Saku.
Aye.
Honorable McKeeva Bush.
No.
Mr. Barney Bush.
No.
Captain Eugene Ebanks.
No.
Mr. Ezra Miller.
No.
Mr. Arden McLean.
No.
The results of the division are as follows. 11 ayes, 5 noes, 1 absentee. The ayes have it. Accordingly, the second reading has been approved.
Second reading, the Second-Hand Dealers Bill 2014.
Recognize the Honorable Minister responsible for Financial Services.
Thank you, Madam Speaker. Madam Speaker, I beg to move the second reading of a bill entitled the Second-Hand Dealers Bill 2014.
The bill has been duly moved. Does the Honorable Minister wish to speak to the bill?
Yes, thank you, Madam Speaker. Madam Speaker, I rise to present the bill on behalf of the government. It's a bill for a law to provide for the regulation of second-hand dealers to deter unlawful property transactions and to facilitate the recovery of stolen property and for incidental and connected purposes. Madam Speaker, the business climate of the Cayman Islands has certainly evolved tremendously in recent years, not just because of new technology and new products, but also because of changes in consumer demands, consumer needs. These changes require a modern framework that sets appropriate standards, protects the interests of consumers, and in some cases even goes beyond that. The establishment of second-hand dealers, including pawnbrokers and businesses involved in the recycling of metals, are representative of the changing needs and changing business activity in our economy. And Madam Speaker, this is, if you look at the, for example, recyclers, those who are involved in recycling of metals, this is a positive activity. This is undoubtedly going to be a part of the future in relation to the waste management strategy and activities in this country. So that's to be encouraged. But Madam Speaker, we have to recognize that it comes with some unique risks as well. So for example, criminals may take advantage of the opportunity to convert pilfered property into quick cash through second-hand dealers. Now, we've had a number of discussions in this Honorable House on the issue, Madam Speaker, of crime, increase in burglaries, and some of the robberies. And as a government, of course, we are absolutely concerned about that. And certainly enforcement and discussions of enforcement activities and stiffer penalties for such antisocial and anti-business behavior is one possible approach. But another important aspect of it is mitigating or restricting and regulating the opportunities to convert to cash value and property taken, thereby hopefully reducing this activity. Now, Madam Speaker, recognizing that such risks exist, the government has worked with stakeholders to determine what should be considered as best practice for this type of business. To date, the Royal Cayman Islands Police Service have had some cooperation from existing second-hand dealers. But there's a clear need for minimum standards and a regulatory framework that can be used to protect the broader interests of our community. Madam Speaker, the bill is envisioned to complement certain operations of the RCIPS, as well as require the implementation of statutory processes and procedures, including obligating local second-hand dealers to keep proper books and records, for example, inventory forms, photographs, copies of picture IDs on who, what, where, when, how they obtained these items that are proposed to be pawned or being offered for sale. This is specific to particularly attractive items in terms of necessity, Madam Speaker, such as jewelry and precious metals, gems and precious stones, and personal electronic devices, cell phones, tablets, laptop, computers, things that are easily removed and carried away. Others will include other household electronic items, TVs, air conditioning units even, as well as other miscellaneous things like boat engines, power tools, all things that have typically been involved in or being removed as part of the theft involved in burglary or such activity. Now, we recognize, Madam Speaker, that this bill isn't going to eradicate the problem of burglaries for the police or the larger community, but it will certainly provide a much needed obligatory regime and regulation which will fight that activity and ultimately provide an enforcement, an investigative tool that will make it more difficult for criminals to use legitimate business establishments to convert stolen property into cash. It will allow better enforcement, better prosecution, and hopefully better deterrence and a reduction in these activities. Madam Speaker, this bill is linked to the Trade and Business Licensing Bill 2014, which this Honorable House has before it for consideration. And that provides for the licensing of second-hand dealers in the Cayman Islands, namely requiring an applicant for a second-hand dealer's license to provide a police clearance certificate with his application, and also to include in the basis for a decision to grant a license for a second-hand dealer's business the board's opinion as to whether the applicant is a fit and proper person to carry on such business. So there's an attempt, or there is a proposed attempt to ensure that people of good reputation, and only those types of people are involved in this business, and not people that would participate in the kinds of activities that we're trying to regulate and curb. In terms of the clauses of the bill, Madam Speaker, it's arranged into 4 separate parts. Part 1 deals with clauses 1, 2, and 3, and addresses the short title and commencement, interpretation, and the application of the bill. This includes reference to Schedule 1, which specifies exempted persons. For example, we wouldn't want the bill necessarily applying to someone who is doing a garage sale at their house. And of course, there are a number of other examples that are set out in Schedule 1 which are appropriate. Part 2, Madam Speaker, includes clauses 4 through 12 and contains provisions relating to the duties of trade officers, police officers, and second-hand dealers under the legislation. This includes the role of trade officers to inspect the premises of second-hand dealers, to ensure compliance with the legislation, and that appropriate records are being kept. The role of the police to notify second-hand dealers of known stolen articles, and the role of the second-hand dealers to report suspicious activity and to hold items suspected of being stolen or being stolen articles. Part 3, Madam Speaker, includes clauses 13 to 25 and contains provisions relating to the operation of second-hand dealing businesses. These include the responsibility of second-hand dealers to maintain employee records and to provide access to trade officers and police officers, to secure their premises, to verify the identity of the individuals transacting business with these dealers, to keep records of transactions as well as records of the disposal of articles. Part 4 of the bill, Madam Speaker, includes clauses 36 to 28 and contains provisions relating to offenses under the legislation and the regulation-making power of Cabinet. Now, Madam Speaker, there are some committee stage amendments which are proposed, and these have been, there are two issues that have been identified subject to the, subsequent rather, to the publication of the bill, one of which is that we want to ensure that the activities of exempt companies that are external to the islands are not inadvertently captured by the law. And the second is to be clear in the requirement that second-hand dealers are to keep and maintain records at their place of business. Madam Speaker, that is a very brief introduction to the bill. I think the bill represents a necessary piece of legislation which, in relation to the activities of pawnbrokers, will stand sort of above as a part of an umbrella over the pawnbrokers law. And it contains a number of very helpful provisions which will enable the unique risks which have been identified to be addressed and to hopefully curb some of the activities and some of the issues which may be taken advantage of in terms of converting stolen property to cash and burglars and thieves obtaining value in that way. So this will hopefully require or allow the police the tool and the opportunity to quell that activity. And I think, Madam Speaker, that will be the end of my presentation on this proposed bill. And I commend the bill to honourable members of this House for passage.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call on the Minister for Financial Services to exercise his right of reply.
Thank you, Madam Speaker. I wasn't expecting that, but I guess it is late in the afternoon. I welcome the tacit acceptance of members of this honourable House for this bill.
The question is that a bill shortly entitled the Second-Hand Dealers Bill 2014 be given a second reading. All those in favour, please say aye.
Aye.
Those against, no. I believe the ayes have it. Accordingly, the Second-Hand Dealers Bill 2014 has been given a second reading. I recognize the Honourable Premier has reached the hour of interruption.
Madam Speaker, before I deal with that, could we have a division with respect to that vote, ma'am?
Madam Clerk, please call a division.
Honourable Alden McLaughlin.
Aye.
Honourable Moses Kirkconnell.
Aye.
Honourable Kurt Tibbett. Honourable Osborne Bodden.
Aye.
Honourable Wayne Panton.
Aye.
Honourable Marco Archer.
Aye.
Honourable Tara Rivers. Honourable Anthony Eden. Mr. Winston Connolly. Mr. Roy McTaggart.
Aye.
Mr. Joseph Hugh.
Aye.
Mr. Elvis Aku. Honourable Makiba Bush.
No.
Mr. Barney Bush. Captain Eugene Ebanks. Mr. Ezra Miller. Mr. Art McLean.
The results of the division are as follows: 9 ayes, 3 noes, 5 absentees. The second reading of the bill entitled Second-Hand Dealers Bill has been given. Honorable Premier, the hour of interruption has arrived.
Thank you, Madam Speaker. Madam Speaker, I beg to move the suspension of Standing Order 10-2 in order that the business of the House may continue beyond the hour of interruption. And Madam, I think we would like to complete the government bills this evening.
The question is that Standing Order 10-2 be suspended. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, Standing Orders 10-2 is suspended.
The Trade and Business License Bill 2014.
Honorable Minister responsible for Financial Services.
Thank you, Madam Speaker. Madam Speaker, I beg to move the second reading of a bill entitled the Trade and Business Licensing Bill 2014.
The bill has been duly moved. Does the mover wish to speak to it?
Thank you, Madam Speaker. Madam Speaker, I rise to present the bill on behalf of the government for a law to repeal and replace the existing Trade and Business Licensing Law 2007 revision to further provide for the regulation of trade and business in the Cayman Islands and for incidental and connected purposes. Madam Speaker, for some time, perhaps as far back as the late 90s, 1999, we've had successive trade and business licensing boards and review committees which have pointed to deficiencies in the trade and business licensing law and suggested ways to address these. And apart from minor changes, primarily to the fee schedule contained in the law, there has been no action to address these concerns that have been identified. Earlier this year, a new committee was established to review the law with the aim of modernizing or suggesting ways to modernize and to potentially merge this legislation with the Local Companies Control Law 2007 revision. The committee, Madam Speaker, included representation from the current board, from the Chamber of Commerce, and from the Caymanian Bar Association. They met on a weekly basis between the 3rd of February and the 28th of April of this year, Madam Speaker. And over the course of that period, the law was reviewed, dissected, and discussed in stages with subsequent suggestions and proposals made by this group. Now, broadly, Madam Speaker, the recommendations of the group can be broken down as follows. A, improvements to the governance structure and processes for the board, including the ability to delegate certain functions to the Department of Commerce and Investment to improve efficiency. B, a focus on supporting Caymanian business owners and creating a local level playing field. C, the introduction of a ticketing system so that offenses do not require to be tied up or tie up the limited time of our courts, thereby enhancing enforcement under the law. D, defining the categories of micro and small businesses to allow for the creation of incentives for these types of businesses. And E, the creation of an appeals tribunal. Madam Speaker, these recommendations, which are reflected in this bill, are intended to improve the ease with which businesses can be licensed by allowing for more streamlined operation of the board and department and greater efficiency, as mentioned earlier. The proposed provisions also have an emphasis on creating a business environment in which there are clear rules to follow, and where there are breaches of these rules, swift action can be taken to enforce them. This creates fairness across our business community, Madam Speaker. It promotes proper competition and allows businesses to succeed in the best possible environment. Madam Speaker, the bill is arranged into 4 parts. Part 1 deals with clauses 1, 2, and 3 and addresses the short title, commencement, interpretation, and application of the bill. Notable new definitions which have been introduced include descriptions of small and micro businesses, as well as a definition of public place. This aims to allow the department to address concerns with illegal vending in public places, which has been a particular issue which has been growing over the past few years. Madam Speaker, the application of the law to exempt certain types of businesses has been modified to clarify the need for non-Caymanians to apply for licenses to conduct activities in primary industries. Part 2 of the bill includes clauses 14 to 16 and contains provisions relating to the operation of the Trade and Business Licensing Board and trade offices. Madam Speaker, the provisions relating to the board have been strengthened, as well as allowing for the delegation of certain functions to the department, that is the Department of Commerce and Investment. For instance, Madam Speaker, it will be possible for the board to delegate the consideration of renewal applications for trade and business licenses to the department, rather than the board having to spend the time dealing with that specifically. This is an example of the desire to seek the greater efficiency and faster turnaround times, which I mentioned earlier, in relation to renewal applications. The identification of specific trade officers is also a new feature. Trade officers will be specifically identified individuals in the Department of Commerce and Investment who will have enforcement powers very similar to that of police constables. Part 3 of the bill includes clauses 17 through 34 and contains provisions relating to licensing. Madam Speaker, this part covers provisions for the actual licensing process that are broadly similar to the process which exists within the current law. The important difference introduced by the bill is the ability of the board to deny an application for specific reasons. For instance, non-compliance with laws relating to pensions, health insurance, labor relations, environmental health, or planning may be grounds for the board to deny an application. Madam Speaker, every day this government gets complaints from businesses in various areas, but particularly those in the construction industry, that there are many companies that are operating without having the same costs, overheads, and without paying pension, without paying health insurance, all this sort of stuff to their employees. And they regard it, rightly so, as unfair competition. So this bill, with these provisions, seeks to address that through a process where there will be an interaction between the Department of Commerce and Investment and the Pensions Office and the Labor Office, where the necessary confirmations can be provided where decisions are being made in relation to renewals or grants. Also in this part, Madam Speaker, are provisions for the information required to be submitted on application and the specification of an offense for the submission of false representation or statements. Now, these provisions will better allow the department to investigate and prosecute individuals who are involved in fronting activities. Part 4 of the bill, Madam Speaker, includes clauses 35 through 42 and contains provisions related to the designation of fixed penalty offenses and the establishment of an appeals tribunal, as well as related miscellaneous provisions. Madam Speaker, one of the challenges that this bill seeks to address is the ability of the department to effectively enforce the law. In the past, the enforcement actions have been limited by the time it takes to get through the court system. So the bill introduces the ticketing system for specific offenses under the law. Clause 35, Madam Speaker, provides that a person served with a ticket has the option of admitting liability for the offense by paying the reduced amount of the fixed penalty or to request a trial. Importantly, this part also makes provision for the appeals tribunal, in which entitles a person aggrieved by or dissatisfied with a decision of the board to appeal to this tribunal. Currently, Madam Speaker, the law provides that appeals are to be dealt with by Cabinet. Madam Speaker, the schedules to the bill deal with fees and offenses. There are some changes to the fee schedule, but primarily those changes relate to an attempt to provide greater clarity in the fee structure and not to add any new fees. Now, Madam Speaker, I've attempted to highlight the main differences between this bill and the current trade and business licensing law. There are obviously other minor changes and tweaks that have not been discussed, but the end result is anticipated to be a vastly improved framework for the licensing of business or businesses conducting activity within these islands. And anything we can do to improve the framework will help our economy, because we cannot have a growing economy, we cannot have job creation without successful businesses operating within it in a fair manner. Now, Madam Speaker, we have some committee stage amendments that will be proposed. Although a great deal of work was done to consult on earlier drafts of this bill to try to identify and address any potential issues, there have been a number of recommendations that have arisen subsequent to the publication of the bill, and we will propose these during committee stage. So, Madam Speaker, in conclusion, I thank the members of the review committee who have put in a lot of time and effort to getting this bill before this Honourable House, and their willingness to assist in the reform of this important piece of legislation. In fact, I thank all of those previous committee members who have served probably over the last 10 plus years at various times, whose work was essentially built upon in order to get this bill before this Honourable House. With that, Madam Speaker, I respectfully commend this bill, the Trade and Business Licensing Bill 2014, to honourable members for passage.
Does any other member wish to speak? I recognize the Leader of the Opposition.
Madam Speaker, every time we need to do something, it gets smothered with processes that most times kills the real aims and objectives of what we are trying to do, what we really need. Madam Speaker, this little country of ours has adopted every conceivable process that weighs far too heavily on our people. In today's Cayman, if you don't get a lawyer, you won't be able to do anything. There are more forms to be completed, more threats in the documents you get. If you don't do this, you can be locked up. And it smothers the entrepreneurial, when it comes to business, spirit. Particularly so because the vast majority of people who are trying to get a little business are not, Madam Speaker, all the time college or university educated that they can even understand what these documents want them to do in applications. So, in other words, Madam Speaker, Madam Speaker, I feel, and you would know this, you work alongside me at times, and you would know that I feel that bureaucracy, far too much bureaucracy, is killing this country. And that's what I'm saying. I just voted against the other bill. People might wonder why. Because we can get what we need without all of these things that people don't understand themselves. The people that are affected don't understand it. They go get a lawyer to explain it to them. And what happens, they end up on the steps of us as elected representatives, expecting us to give them the guidance all the time. Sometimes we can, other times we can't. But that's what I see happen. I've watched the legislation grow from small pieces here in the last 30 years to huge bills to get things done that I think it should be quite easy to spell out. I'm not here, Madam Speaker, decrying or crying down legal department. I know how hard they work to get the aims and objectives of the government. Sometimes so convoluted that you can't understand. I don't know how the legal minds themselves can understand, because what happens, Madam Speaker, is that as politicians, as people that are being elected, we're trying to please everybody. So when the draft go to request for legislation, half it doesn't tell the story, and Madam Speaker, the facts to bear that out is when you bring a piece of legislation here, you get as many amendments to it as the bill itself, trying to please everybody, and it becomes so convoluted you can't understand it when it's all done. So, not that I knock against the aims and objectives of what the government trying to do in the other bill, for instance. It is just that I think that they can get it done in a much simpler way and be as effective. Madam Speaker, the bill before us, in the procedure for application, for instance, has been significantly increased together with the documentation required. It is going to put additional burdens and expense on anyone applying for a trade and business license, and will, of course, make it much harder and more expensive for young entrepreneurs who wish to start a business so to do. The provisions in the law, which after a warrant has been obtained either by a justice of the peace or through a judge, will place also in the hands of persons who are not likely to be trained in the law powers to seize books, records, and all the equipment of a business which the persons on the board believe to be operating outside the trade and business license law. To me, that is draconian. That could be abused. It certainly would be my recommendation that before any powers of search and seizure of assets are exercised, that an application be made to the court supported by relevant affidavits, and that the court should make a decision as to whether the seizure of a person's documents and business equipment is justified in the circumstances. Madam Speaker, it should be noted that under the law, there is no provision for the return of a person's documents, etc., and that when computers and documents are seized from a business, there is no way for the persons who own and operate the business to know who they owe, what their stock is, and that also can lead to significant hardship and injustice. And so, in the light of these things, it is my opinion that more careful consideration is given before giving those types of powers in a board, and that if the government wishes to proceed, they should change those provisions so that they could only be exercised with an order of the court, supported by proper documentation and affidavits. Madam Speaker, as I said in opening here, we cannot continue to make it harder for the people that we are trying to help, for business people to open businesses and extend the bureaucracy beyond what it is already. If we do, we can expect less businesses to be opened in Cayman and more young Caymanians to be driven out of business, perhaps go somewhere else to do business. The government, Madam Speaker, I think, hopefully would take note of what I'm saying, that countries such as the United Kingdom and the United States are seeking to cut bureaucracy in order to encourage businesses to be opened and operated without overburdening government regulations. Cameron's, and I repeat this, Cameron's edict to the British Business Bureau said that they were cutting tons of regulations in order to entice business to the UK. He said there were over 1,000 pages of regulations that he was cutting out of planning to assist their business approach and to encourage investment in the United Kingdom. We here in these islands, it seems, at the same time, governments seeking to expand government regulations and bureaucracy. That is my complete. The aims and objectives are being smothered. What we are trying to do to help becomes a drawback in far too many instances. And so if the government goes ahead, goes through the aspect of it I have spoken to, then go to court. That's the proper rule of law provision. That's where we should be, not to the board who can go and take people computers and take people business and that sort of thing. If I'm wrong in reading the bill, then perhaps somebody will enlighten me, but that's what I see in the bill. I think the government in producing this, there are other areas, but I certainly can't support the bill with these sort of draconian powers vested in a board. People's business, people's computers, and everybody is using a computer today. And in the frame of mind that exists in our islands where everybody is making a complaint against somebody. There are FIO, freedom of information, and everybody is complaining about somebody. And people have to defend themselves. Against what? Against who? Board comes in, takes away your computer, sees your documents. These are the areas I am concerned with. I do hope that the government will reconsider that. As I said, if they're going ahead with it, to make sure that it is done through a proper court of law rather than ordinary board members, no matter who they are. Thank you, Madam Speaker.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call upon the mover if he wishes to exercise the right of reply.
Madam Speaker, thank you. If I could have 30 seconds before proceeding. Madam Speaker, I appreciate the comments from the Leader of the Opposition. I understand the concerns that he has articulated, and certainly the views of this government is to ensure that this legislation that governs the licensing of businesses within the Cayman Islands provides an efficient framework through which the licensing can be carried out quickly, renewals can be carried out quickly and more efficiently than have been done in the past. And we want a framework which facilitates the growth of business, facilitates the growth of the economy. I'm happy to say, Madam Speaker, that we don't have a 1,000-page problem. The current law is 30 sections. This bill, as proposed, only extends that to 42 sections, Madam Speaker. So nothing very significant, but it contains some important provisions which will allow the board to function better, to make better decisions, to make decisions more rapidly, to deliver licenses more quickly. So this issue and this concern which the member articulates of bureaucracy is one that we are cognizant of and certainly do not wish to see any greater degree of bureaucracy introduced in this country than may be absolutely necessary to properly regulate the business environment through which businesses operate. The requirements for the licenses, the application requirements, are all very similar to what exists currently. And we certainly recognize, notwithstanding that, Madam Speaker, that there are, anytime you have a new bill, a new piece of legislation, which is either standalone or which repeals and replaces, there is an opportunity that should be taken advantage of in terms of educating the public, in terms of making sure that the business community understands and are not overly concerned as to what the requirements are, and that they're not unduly onerous, not significantly different from what is currently in existence. Madam Speaker, the Leader of the Opposition spent some time talking about the removal, the search and removal and seizure of computers and records, I think he referred to. I think he also mentioned that he didn't see any reference to a return of any records that may have been seized as a part of any investigation. Madam Speaker, Clause 17(7) of the bill contains specific provision for the return of such seized property. It provides any document, record, equipment, or other property seized under a search warrant under this section shall, A, where legal proceedings are not commenced within a period of 30 days from the date of seizure of the document, record, equipment, or other property, be returned to the owner. Or B, where legal proceedings are commenced within a period of 30 days of the seizure, be kept until the conclusion of those proceedings. Now, Madam Speaker, the member there is a, let me rephrase that, there's a proposed amendment, committee stage amendment to section 28 of the bill, Madam Speaker, which provides that a warrant will be required so in terms of breaches by a licensee, which is covered by section 28, we are proposing an amendment which will apply an obligation to obtain a warrant in respect of the entirety of section 28(1). Madam Speaker, I think that should address the concern which the Leader of the Opposition articulated. As far as I can understand it, I know he didn't go into specifics by reference to sections, so I don't know that I have answered every aspect of the bill which may be relevant to the general point that he made. But I think those two address those points. And Madam Speaker, I know that the leaders again are articulating his view that there's too much bureaucracy. Well, we have had, as I said, for more than a decade, we have had committees and boards which have been frustrated with the limited environment within which they have had to operate under the existing trade and business licensing law, in an environment where the economy and the level of business activity is evolving, is growing, and has become more complex. So clearly there have been a number of issues that have been identified, and there are clearly complaints that businesses are not operating in an environment where there is fair competition. The bill seeks to address a number of the existing concerns, the long-standing concerns, address some of these concerns in the areas of fair competition to make sure that everybody is effectively bearing the same overhead costs that is mandated by other national laws of general application. And also, Madam Speaker, to improve the environment within which the licensing can occur rapidly, the renewals can occur rapidly. Because we know, Madam Speaker, that the time that business people have to invest in this process is valuable. It is time which they could be dedicating to their businesses, to growing their businesses, to adding to the economy, to creating jobs, creating value for themselves and their families. So our objective is to create a modern, efficient framework which addresses concerns and speeds up the process and allows the board to function at a high level with the assistance of the Department of Commerce and Investment. Just as an example in terms of efficiency, Madam Speaker, there are provisions in the bill which allow for the boards to, rather than having to gather together in one location and physically meet and consider the agenda and make decisions, they can sit in their offices, log on through an access, go through telephone, through a conference line, and consider the agenda and make decisions. And that will greatly speed things up, because these people serve and give willingly of their time as well, Madam Speaker. A lot of people in Cayman, a lot of good people in Cayman, professionals, lay people, others who serve on these boards, they are generous with their time. And this sort of facility allows the process to be accelerated, yet the integrity to remain and the efficiency to improve. So, Madam Speaker, with that, I say thank you very much, and I will take my seat.
The question is that a bill shortly entitled the Trade and Business License Bill 2014 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no.
No.
The ayes have it. Accordingly, the Trade and Business License Bill 2014 has been given a second reading. The House will now go into committee to consider the three bills. Please be seated. The House is now in committee, and with the leave of the House, may I assume that, as usual, we will authorize the Honourable Attorney General to make minor corrections on such as these bills. I'd ask the clerk to now please state the bill and read the relevant clauses.
Clause, the Second-Hand Dealers Bill 2014. Clause 1, short title and commencement.
The question is that the Clause 1 of the bill The question is that Clause 1 stands part of the bill. All those in favour, please say aye.
Aye. Aye.
Those against, no. The ayes have it. Clause 1 stands part of the bill.
Clause 2, interpretation.
Honourable Minister, I believe you have an amendment.
Yes, thank you, Madam Chair. Madam Chair, in accordance with the provision of Standing Orders 52.1 and 2, I, Wayne Panton, the Minister responsible for Commerce, give notice to move the following amendments for the Second-Hand Dealers Bill 2014. And that is that the bill be amended in Clause 2 as follows. A, in the definition of the word article, delete the words, quote, that does not appear on the list of prohibited trade articles in Schedule 2, close quote. And B, in the definition of the words premises of a second-hand dealer, 1, insert after the words premises of a second-hand dealer the words, quote, or, quote, premises, close quote. And 2, in paragraph A Roman 1, delete the words, quote, that or, close quote, and substitute the words, quote, that provides for, close quote. And C, in the definition of the words, quote, second-hand dealer, close quote, in paragraph A, insert after the words, quote, conducts business, close quote, the words, quote, within the islands, close quote.
The amendment has been duly moved. Does any member wish to speak to the amendment? If not, I'll put the question that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. I will now put the question that the clause as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The clause as amended now stand part of the bill.
Clause 3, exempt persons. Clause 4, chief officer to assign trade officers. Clause 5, inspections. Clause 6, powers of a police officer. Clause 7, information. Clause 8, commission to inform second-hand dealers of stolen article. Clause 9, obligation to report offer of articles on list. Clause 10, suspicious activity report. Clause 11, obligation to report possession of suspect article. Clause 12, notice to hold.
The question is that clauses 3 through 12 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 3 through 12 now stand part of the bill.
Clause 13, prohibited trade articles. Clause 14, employee records. Clause 15, access to employee records. Clause 16, hours of business. Clause 17, premises to be secured. Clause 18, no transactions with children. Clause 19, verification of identity. Clause 20, statement of ownership. Clause 21, transaction records to be kept. Clause 22, second-hand dealer to allow inspection. Clause 23, obligation to retain article in unaltered state. Clause 24, disposal of articles by dealers. Clause 25, export of articles.
The question is that clauses 13 through 25 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 13 through 25 now stand part of the bill.
Clause 26, offenses. Clause 27, immunity. Clause 28, regulations.
Question is that clauses 26 through 28 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 26 to 28 now stand part of the bill.
Schedule 1, exempt persons. Schedule 2, prohibited trade articles.
The question is that schedules 1 and 2 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Schedules 1 and 2 stand part of the bill.
Schedule 3, statement of ownership form.
The question is that Schedule 3 stands part of the bill. All those in favor, please say aye.
Aye.
Those against, no. Schedule 3 now stands part of the bill.
A bill for a law to provide for the regulation of second-hand dealers, to deter unlawful property transactions, and to facilitate the recovery of stolen property, and for incidental and connected purposes.
The question is that the title now stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title now stands part of the bill.
The Trade and Business Licensing Bill, 2014, Clause 1, short title and commencement.
The question is that Clause 1 stand part of the bill. All those in favor, please say aye.
Aye. Aye.
Those against, no. The ayes have it. Clause 1 now stand part of the bill.
Clause 2, interpretation.
Honorable Minister, you have an amendment.
I do. Thank you, Madam Chair. Madam Chair, in accordance with the provisions of Standing Order 52.1 and 2, I, Wayne Panton, Minister responsible for Commerce, give notice to move the following amendments to the Trade and Business Licensing Bill 2014. That the bill be amended as follows. A, in Clause 2, 1, by inserting in the appropriate alphabetical sequence the following definition, quote, Caymanian owned and controlled, close quote, means in the case of a company where no less than 60% of A, the voting rights attached to each class of shares in the company is beneficially held by Caymanians, and B, the directors of the company are Caymanian, and that 60% of the voting rights and directorships is enjoyed by Caymanians to the exclusion of any other person, and cannot, by means of an arrangement, artifice, or device, be exercised either directly or indirectly by persons who are not Caymanian. And in the definition of the words, quote, trade and business, close quote, by inserting after the words manufacture, or quote, manufacture, comma, mercantile, close quote, the word, quote, wholesale. B in clause, no, sorry. I believe I should stop at the amendments to clause 2.
The amendment has been moved. Does any member wish to speak to it? If no member wish to speak, I put the question that amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. I now put the question that the clause as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended now stand part of the bill.
Clause 3, application.
Honorable Minister, there is an amendment.
Madam Chair, thank you. Madam Chair, I propose an amendment to clause 3A by inserting after the words, quote, this law, close quote, the following words, quote, including where that other law exempts a person to whom it applies from registering, comma, being licensed, or paying a fee, close quote.
The amendment has been moved. Does any member wish to speak to it? If not, I put a question that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. I now put the question that the clause as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended now stands part of the bill.
Clause 4, establishment of the board. Clause 5, functions of the board.
The question is that clauses 4 and 5 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 4 and 5 now stands part of the bill.
Clause 6, delegation by the board.
There's an amendment to clause 6. Honorable Minister.
Thank you, Madam Chair. Madam Chair, I propose an amendment to clause 6.1b by deleting the words, quote, by way of, close quote, and subparagraphs Roman 1, Roman 2, Roman 3, and Roman 4.
The amendment has been moved. Does any member wish to speak to it? If not, I put the question that amendment stands part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. I further put the question that the clause as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended now stand part of the bill.
Clause 7, trade officers. Clause 8, policy directions. Clause 9, composition of the board.
The question is that clauses 7 through 9 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 7 to 9 now stand part of the bill.
Clause 10, duration of appointment.
There's an amendment to clause 10, Honourable Minister.
Thank you, Madam Chair. Madam Chair, I propose an amendment to clause 10 as follows. Roman 1 by deleting subclause 2 as substituting the following subclause 2. The Cabinet may appoint any person in the place of the Chairman or any member of the Board where the Chairman or a member of the Board is removed or has vacated the office. Close quote. In subclause 8 of clause 10, by inserting after the words, quote, 3 of its members, close quote, the words, the majority of whom shall be members from the private sector, close quote. And by inserting after subclause 11, the following subclause 12. For the purposes of this part, quote, minutes, close quote, includes any electronic record or transcript of votes or decisions made during a meeting that takes place by means of conference telephone, computer, or similar equipment. Close quote.
The amendment has been moved. Does any member wish to speak to it? If not, I put the question that amendments sound part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 10 is amended. I put the question that clause 10 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 10 as amended now stand part of the bill.
Clause 11, disqualification from being a board member.
There is also an amendment, Honourable Minister, for 11.2.
Yes, thank you, Madam Chair. Madam Chair, I move the following amendment to clause 11.2, which is the deletion of clause 11.2 and substituting the following clause to members of the board shall hold office at the Cabinet's pleasure. Close quote.
The amendment has been duly moved. Does any member wish to speak to it? If not, I put the question that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Those
Aye.
against, no. The ayes have it. I put a question that clause 11 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 11 as amended now stand part of the bill.
Clause 12, Secretariat. Clause 13, validity of any act. Clause 14, duty of confidentiality. Clause 15, board members' interest. Clause 16, protection from liability and indemnity. Clause 17, requirement for license.
The question is that clauses 12 through 17 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 12 through 17 now stand part of the bill.
Clause 18, application for grant or renewal of a license.
Honourable Minister, there's an amendment to 18.
Thank you, Madam Chair. Madam Chair, I move an amendment to Clause 18, or in Clause 18, Subclause 2B1, by deleting the words, quote, "that is at least 1 year old, a stamped copy of the company's annual return, and a return of shareholdings containing," close quote. And 2, by inserting after subclause 2B1 the following paragraph, Roman 1A. In the case of a company that is at least 1 year old, a stamped copy of the company's annual return and a return of shareholdings containing the particulars listed in subparagraphs Roman 1A to E. Further, Madam Chair, in subclause 2B Roman 3, by inserting before the words, quote, "a police clearance," close quote, the words, quote, "in the case of an application for the grant of a license only," close quote, and in subclause 2B4, by inserting before the words, quote, "a bank reference," close quote, the words, quote, "in the case of an application for the grant of a license only," close quote. And by deleting subclause 4 and substituting the following subclause 4, where a company is not Caymanian owned and controlled, the applicant shall, unless exempted by the Local Companies Control Law 2007 revision, apply for a license under that law prior to applying for a license under this law.
The amendment has been moved. Does any member wish to speak to it? If not, I put the question that amendment stand part of the clause. All those in favor, please say aye. Aye. Those against, no. The ayes have it. The amendment stands part of the clause. And I'll put the question that clause 18 as amended stand part of the bill. All those in favor, please say aye. Aye. Against, no. The ayes have it. Clause 18 as amended now stand part of the bill.
Clause 19, restriction on grant or renewal of a license.
Honourable Minister, there's an amendment to clause 19.
Yes, thank you, Madam Chair. Madam Chair, I move an amendment to clause 19(2) by inserting after paragraph A the following paragraph, AA, identical or similar to a registered trademark unless it is established that the trade or business is the owner of the trademark or it has a license to use the trademark.
The amendment has been moved. If no one wishes to speak, I put the question that amendment stand part of the clause. All those in favor, please say aye. 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 Those against, no. The ayes have it. Clause 19, I put the question as amended stand part of the bill. All those in favor, please say aye. Aye. Those against, no. The ayes have it. Clause 19 as amended now stand part of the bill.
Clause 20, request for additional information. Clause 21, grant of license and expedited license. Clause 22, evidence of license and public display of license. Clause 23, validity of license and renewal fee. Clause 24, transfer of license. Clause 25, amendment of license.
I put the question that clauses 20 to 25 stand part of the bill. All those in favor, please say aye. 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 Those against, no. The ayes have it. Clauses 20 through 25 now stand part of the bill.
Clause 26.
There's an amendment to clause 26, Honourable Minister.
Yes, thank you, Madam Chair.
Oh.
Madam Chair, I move...
Sorry, Minister. Haven't given the clerk a time to read it.
Oh, I'm sorry.
Clause 26, notification of change of addresses, etc.
Honourable Minister, please proceed with your amendment.
Thank you, Madam Chair. Madam Chair, I move an amendment to clause 26.1 by deleting the word, quote, forthwith, and inserting after the words, quote, the board, the words, no later than 30 days after such change of address, corporate identity, or scope.
The amendment has been moved. If no member wishes to speak, I put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. I will now put the question that clause 26 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 26 as amended now stand part of the bill.
Clause 27, surrender of license.
I put the question that clause 27 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 27 now stands part of the bill.
Clause 28, breaches of license.
Madam Chair, I'm seeking your guidance at this point. In light of some of the comments made by the Leader of the Opposition, there is one potential amendment that we could make by inserting an additional subclause 6 dealing with the return of property. I'm not sure whether that is something that I can do as from the floor, or whether we need to submit notice.
You can move it on the floor. You have it ready?
I do.
Okay, please proceed.
Thank you, Madam Chair. Madam Chair, in accordance with appropriate standing orders, and as Minister responsible for Commerce, I give notice to move the following amendment to clause 28 by adding a new subclause 6, which would read, any document or record seized or removed under the under this section for the purpose of examination or inspection shall be returned promptly on completion of the examination or inspection.
The amendment has been duly moved. Does any member wish to speak to it? Member from Northside.
Only to say, Madam Chairman, that you don't have a quorum, so you can't take a vote on the amendment. Call it Premier back in, you'll have a quorum, but you don't have one
Ensure
right now.
that we have 10 as a lack of quorum has been brought to my attention. We have 15 minutes to be quorum.
Premier. Where's Minister Archer? Sergeant on home too. Oh my Lord.
The question is that a new subclause be added? All those in favor, please say aye.
Aye.
Those
Aye.
against, no. The ayes have it. Accordingly, a new subclause has been added to clause 28. You have other amendments, Minister, to clause 28?
I do, Madam Chair, and I apologize. I should have completed those two amendments first before proposing the new one to address the issue raised by the the Leader of the Opposition. I move, Madam Chair, an amendment to subclause 1 by inserting after the words, quote, in relation to the licensee and may, close quote, the words, quote, upon obtaining a warrant, close quote, and 2, in subclause 1A, by deleting the words, quote, upon obtaining a warrant, close quote.
The amendment has been moved. Is there any further debate? If not, I put the question that clause 28 as amended, sign part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 28 as amended, sign part of the clause. And I put the question that clause 28 as amended, sign part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 28 now stands part of the bill.
Clause 29, suspension or revocation of license. Clause 30, revocation order. Clause 31, revocation under Local Companies Control Law 2007 revision. Clause 32, register. Clause 33, permission under other laws. Clause 34, restriction on the use of the word license.
The question is that clauses 29 to 34 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 29 to 34 now stand part of the bill.
Clauses 35, tickable offenses. Clause 36, appeals tribunal. Clause 37, appeals from decisions of the board. Clause 38, conduct of appeals. Clause 39, offenses by officers of body corporate. Clause 40, regulations. Clause 41, repeal of trade and business licensing law 2007 revision. Clause 42, savings and transitional provisions.
The question is that clauses 35 through 42 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 35 to 42 now stand part of the bill.
Schedule 1, fees. Schedule 2, ticketable offenses. Schedule 3, ticket.
Question is that schedules 1 through 3 stands part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 3 now stands part of the bill. Sorry, thank you for the correction. Schedules 1 through 3. Thanks.
A bill for a law to repeal and replace the Trade and Business Licensing Law 2007 revision to further provide for the regulation of trade and business in the Cayman Islands and to provide for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title now stands part of the bill.
The Summer Jurisdiction Amendment Bill 2014. Clause 1, short titling commencement. Clause 2, insertion of section 43A and 43 to 43E in the Summer Jurisdiction Law 2006 revision. Training, suspension of appointment, honorary title, retention of appointment, regulations. Clause Clause 3, transitional.
The question is that clauses 1, 2, and 3 stand part of the bill. All those in favor, please say aye.
Madam Chair.
Sorry, member from Northside.
I know I don't have the authority to move it, but I wonder if the Premier would consider moving an amendment to, in clause 2 to 43E, which says, it now reads the Cabinet may make regulations. if the government would consider agreeing to inserting after consultation with the Chief Justice.
Honorable Premier.
Madam Chair, that is what is done in practice, so we don't have any difficulty with that. Madam Chair, in accordance with Standing Order 52.2, I move the following amendment to Clause 43D.
Is Clause 2 you're talking about?
Yes, it's Clause 2, but it's Clause 2, 43D.
Yeah.
1, 2, 3, 4, 5. In line 6, after the words Justice of the Peace, insert after consultation with the Chief Justice. No, that's wrong. That's wrong. That's wrong. Right. My fault, Madam Chair. I got it marked. The wrong bit is on the line. So let me start over. In accordance with Standing Order 52.2, 43E, I move that Clause 2, 43E, be amended by inserting after the words "the Cabinet" in the first line, after the following, after consultation with the Chief Justice, so that the subclause reads, "The Cabinet, after consultation with the Chief Justice, may make regulations prescribing all matters that are required or permitted by this law to be prescribed or are necessary or convenient to be prescribed for giving effect to the purposes of this law," etc.
The amendment has been moved. Does any member wish to speak to it? If not, I put the question at Clause 2. Okay. Because you just moved it. I put a question at Clause 1, stand power of the bill. All those in favor, please say aye.
Aye.
All those against, say no. The ayes have it. Clause 1 stands power of the bill. I put the question that the amendment to Clause 2 stands part of the clause. All those in favor, please say aye. Aye. Those against, no. The ayes have it. Clause 2 as amended stands part of the clause. I put the question that the clause as amended now stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 2 as amended now stand part of the bill. And I put the question at Clause 3 stands part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 3 now stands part of the bill.
A bill for a law to amend the Summary Jurisdiction Law 2006 revision to empower the Cabinet to make regulations, providing for the training of justices of the peace and for incidental and connected purposes.
I put the question that the title now stand part of the bill. All those in favor, please say aye.
Aye.
All those against, no. The ayes have it. The title now stand part of the bill. That concludes proceedings in committee. Please be seated. The House is now resumed.
Report on bills. The Second-Hand Dealers Bill 2014.
The Honorable Premier. Sorry. The Honorable Minister for Financial Services.
Thank you, Madam Chair. Madam Chair, I am to report, sorry, Madam Speaker, let me revert. Madam Speaker, I am to report that a bill short titled the Second-Hand Dealers Bill 2014 was considered by a committee of the whole House and passed with amendments.
The bill has been duly reported and is set down for its third reading.
The Trade and Business Licensing Bill 2014.
Honorable Minister for Financial Services.
Madam Speaker, I am to report that a bill short titled the Trade and Business Licensing Bill 2014 was considered by a committee of the whole House and passed with amendments.
The bill has been duly reported and is now set down for its third reading.
The Summer Jurisdiction Amendment Bill 2014.
Honorable Premier.
Thank you, Madam Speaker. Madam Speaker, I am to report that a bill shortly entitled the Summer Jurisdiction Amendment Bill 2014 was considered by a committee of the whole House and passed without amendment.
The bill has been duly reported and is set down for its third reading.
Third readings. The Second-Hand Dealers Bill 2014.
Honorable Minister for Financial Services.
Thank you, Madam Speaker. Madam Speaker, I move that a bill shortly entitled the Second-Hand Dealers Bill 2014 be given a third reading and passed.
The question is that a bill shortly entitled Second-Hand Dealers Bill 2014 be given a third reading and pass. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Second-Hand Dealers Bill 2014 has been read a third time and is now passed.
The Trade and Business Licensing Bill 2014.
Honorable Minister for Financial Services.
Thank you, Madam Speaker. Madam Speaker, I move that a bill shortly entitled the Trade and Business Licensing Bill 2014 be given a third reading and passed.
The question is that a bill shortly entitled the Trade and Business Licensing Bill 2014 be given a third reading and passed. All those in favor, please say aye.
Aye. Aye.
Those against, no.
No.
I believe the ayes have it. The Trade and Business License Bill 2014 has been read a third time and is now passed.
The Summer Jurisdiction Amendment Bill 2014.
Honorable Premier.
Madam Speaker, I move that a bill shortly entitled the Summer Jurisdiction Amendment Bill 2014 be given a third reading and passed.
The question is that the Summary Jurisdiction Amendment Bill 2014 be given a third reading and passed. All those in favor, please say aye.
Aye.
Those against, no.
No.
I believe the ayes have it. The Summary Jurisdiction Amendment Bill 2014 has been given a third reading and is now passed. I recognize the Honorable Premier.
Thank you, Madam Speaker. Madam Speaker, we have gotten through all of the government business, for which I am most grateful to all members of this Honorable House for their cooperation and assistance. Madam Speaker, we still have 5 private members' motions and a number of questions, and I propose to adjourn the House until Monday, December the 8th at 10 a.m., when we will consider those matters.
The question is that the Honorable House now do adjourn until Monday, December 8th. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, the House now stands adjourned until Monday, December 8th, 10 a.m.